Yes, good evening to the aspirants of the JCJ 2022 main examination, and we are dealing the attachment of the property, and we dealt the part 1, part 2, today is the part 3, most probably that I am going to wind up attachment of the property of the under CPC. Read what I posted on the screen. Anyone can unmute and read? Read what I posted on the screen so that I could know that you are with me and I am with you, or both are traveling the same boat to reach to the destination.
Welcome to the aspirants JCJ 2022 main examination procedure in execution under the Civil Procedure Code.
And we
Professor
studied in the
Dr.
last class, yes. Professor Dr. Mohammed Saheb Hussain, Professor of Law, South Mwanza, Tanzania. Yes, in my yesterday class, we are up to here because I put the asterisk mark. Yes, this is the asterisk mark. What is the spelling of the asterisk? What is the spelling of asterisk? If you know it, you tell me. If you don't know it, you say pass on. Are you hearing me?
Yes, sir. Pass on, sir.
Yes, I already told you asterisk. Then I will show you the practical way. Yes. What is the spelling? ASTERISK or CK? Spelling, read the spelling. Read the spelling which I posted on the screen.
ASTERISK.
Yes, ASTERISK, asterisk mark that is. Okay. Now let us go to our main point here. Yes, Order 21 Rule 55 to 38 explains. Is it 55 to 38 or 55 to 58?
58, sir.
I think it is 58, not to my knowledge goes. Explains the circumstances and the rules that attach. Yes.
Maybe 38 to 55, sir.
Okay, 38 to 55. Okay, subject to the correction. Let me see it because I did not verify it. 38 to 55. Is it?
Yes, sir.
Okay, let me presume it now. And of course, subject to the corrections of the rules, explains the circumstances under which the attachment is determined under the code. Number 1. Read anyone. Arshia, read number 1.
Yes, sir. Order 21, Rule 38 to 55 explains the circumstances under which the attachment is determined under the code. Number 1, where the decretal amount is paid or is satisfied. Number 2, where the decree is reversed or set aside. Number 3, where the court highlights an objection against the attachment and makes an order for releasing the property. Number 4, where after the attachment the application for execution is dismissed. Number 5, where the judgment holds withdraws the attachment. Number 6, where the decree holder fails to do what he was required to do under the decree. Number 7, where the suit of the plaintiff is dismissed. Number 8, where the attachment is ordered before the judgment and the defendant furnishes necessary security. Number 9, where there is an agreement or compromise made between the parties. And
Yes.
Number 10, where the creditor abandons the attachment.
Yes. See, keep in the mind, the last but one goes with the and here. This is the last but one. It goes with the and. And now let us explain the number 1 is concerned. Where the decretal amount means which is decreed by the court, it is called decretal amount, is paid or is satisfied. So, once decretal amount is satisfied, and then there is no question of attaching the property. Am I right?
Yes, sir.
Okay, number 2, where the decree is reversed or set aside. After some time, the decreed amount, by further it may be set aside or the reversed also. At the time also attachment cannot be done. And where the court highlights an objection against attachment and makes an order for releasing the property. It makes an objection, need not be attached. Because we yesterday in the class, what are the properties which cannot be attached? We read the properties. Can you tell me that what are the properties which cannot be attached? We read at least 8 to 9.
Vessels, tools of artisan, clothes, beddings, wife and children of the judgment debtor, salaries, pensions, gratitudes, etc. Sir.
Stipends.
Yes,
So
sir.
these are the things could not be attached over there because for their livelihood they are making it out. If they attached it, they could not have their own livelihood. So that was the point which is made over there. So where after the attachment the application for the execution is dismissed. Of course, the execution of the attachment will be dismissed because by the time either the judgment debtor paid the amount or there is no necessity of the attachment because the decretal amount is satisfied or enough. At that instance, the execution is dismissed. What execution of what?
Degree.
Decree. Very good. So where the judgment holder withdraws the attachment. Who is the judgment holders here? Plaintiff or
Plaintiff,
defendant?
sir. Plaintiff.
Plaintiff. If plaintiff withdraws the attachment amount at that time, attachment, there is no question of attachment. Where the decree holder fails to do what he was required to do under the decree. Suppose if he doesn't want the execution should be made over there and he will not carry out it, he will not move the execution petition. At the time also attachment could be set aside or could not be done. And where the suit of the plaintiff is dismissed, which suit? Execution petition suit is dismissed over there. Where the attachment is order is before the judgment and the defendant furnishes the necessary securities. Before the attachment, if the defendant furnishes the security would be there, naturally that property will not be attached. Am I right?
Yes, sir.
There is no attachment for the mortgage. Why? This is the mortgage property is the guarantee. If he is in case of the default, they will sell the property. Am I right?
Yes, sir.
Okay. Now, where there is an agreement or a compromise made between the parties, of course, there is a compromise would be there. At that instance, no question of attachment. And the last one is where the creditor abandons that attachment. And here the creditor means the person who has given the loan. Am I right?
Yes, sir.
And if he abandons the attachment, there is no question of attachment would be there. So these are the 10 conditions where attachment would be set aside or could not be done. So now let us see the private alienation of the property after attachment. How alienation of the property would be there after attachment is. Section 64, subsection 1 states that the private alienation of the property made after the attachment is void as against the claims enforceable under the attachment. How? Section 64 subsection 2 clarifies that this section is not applicable in case of transfer of property in pursuance of the contract entered into before the attachment. Suppose the attachment, before the attachment there would be any contract would be there, at that instance attachment could be set aside. And this provision is inserted in the court to stop any kind of the fraud on decree holders and to keep the interest of the judgment creditors and who are entitled to be satisfied out of the assets of the judgment debtor. See, the provision they made it out because if once they are satisfied over there, or if any fault is found, or if there is any fraud is made in the judgment debtors getting the decree by the decree holder, at the time they will stop the attachment. And these provisions in a way interferes with the rights of the owner in alienating his property and hence construed strictly. So attachment proceedings or section, they should be strictly construed. And the order, the subject matter and everything should be followed according to the mode of attachment. And we studied what is the mode of attachment. Is it not?
Yes, sir.
Good. However, since it is for the benefit of the creditor, he can waive the benefit. Of course, the creators, it's a wish, will and wish that he can waive the benefit also, if he wants. A private transfer here means voluntary transfer like a sale, lease, gift, mortgage. All these are come under the modes of transferring the property. Am I right?
Yes, sir.
The transfer directed by the court is not included in a private transfer. Of course, in the private transfer, the terms and conditions holds good and which are agreed by the parties. Therefore, a private transfer in contravention of the Section 4 is not wholly void against all other circumstances, but is void only against the claim enforceable under the attachment and only to the extent necessary to meet those claims. See, the question comes when the private contract is concerned, okay, they can make any provisions of their terms and condition, but that provision should not be against the public policy, number one, and that provisions in the terms and condition in the contract should not be against the existing law of the country. Another point is, it should not be any contravention with the grand norm of the country. What is the grand norm of the country?
Basic law, sir.
Here, grand norm in the sense, constitution.
Law of the land.
Law of the land, especially, what is the biggest law of the land?
Constitution of India.
Constitution. Any enactment in contravention with the constitution becomes
Ultraverse.
no, null and void. So now the constitution is a hub. Do you know what is hub? Do you know what is hub?
Gathering of all the subjects.
Do you know cycle? Do you know bicycle?
Yes, sir.
Do you know the bicycle having the wheel?
Yes, sir.
Where the hub would be there? See, here I am showing the hub. Did you see the hub?
Yes, sir.
Here. And the hub is the constitution, and these are called what is these are called? Even myself also, I know it is not strokes, not spikes. Let me remember it. Spokes. What are called?
Spokes.
Spokes. Images. See, did you see the spokes?
Yes, sir.
This is a hub. And this is the spokes. And what about this one? I am showing the cursor.
Wheel.
Of course, it's a wheel, no doubt it is, but its a specific name is there. It is a rim. RIM, rim.
Yes, sir.
And after the rim, what would be there in here? The outer part? Outer
Tire,
part.
sir. Tire, sir.
Tire. What is the inside of the tire?
Tube.
Yes. Of course, unless it is a tubeless tire. Is it clear?
Yes, sir.
Yes. Now this is the constitution, and the spokes are the statutes and acts, and the rim, tire, and tube is the society. Are you following me?
Yes, sir.
If anything contravention with the hub, not coordinating with the hub, and it becomes null and void. Means the spokes null and void. What are the spokes?
Laws, sir. Various laws of the country.
State the acts or statutes, whatever it may be, the enactments, spokes. Why these enactments and acts? To run the society in a smooth way. Am I right?
Yes, sir.
So that is the call. See, the hub, constitution is the hub, and the spokes are like the statutes and the enactments, and the rim is the society. Of course, it's a and here tire and tubes are we can say rules and regulations. If it is so, is it clear?
Yes, sir.
So now the constitution is there. So they made it very much clear in this one. Section 64, subsection 2 says, clarifies that this section is not applicable in case of transfer of property in pursuance of the contract entered before the judgment. If the judgment, before the judgment, if any contract would be made over there, that is a valid contract. I don't know whether you study the private international law. Am I right?
Yes, sir.
In the private international law, you have every liberty to make the contract, the terms and conditions. But that condition should not be in contravention with the existing laws, not in contravention with the public policy, not in contravention with the constitution. If it is so, okay, you can make the contract. There in the private contract, especially private international law contract, you can choose any law applicable over there, even though the party is not from their respective countries. For instance, there is a contract of mercantile through the sale. Here, loading and unloading with the vessel. That is a contract between India and any other country. Let you say Singapore or let you say Japan. See, most of the iron ore will be supplied from the Visakhapatnam airport to the Japan. Am I right? Sir, we don't know.
Yes, sir.
And at the time, if any breach occurred over there in the vessels, I mean, we can say this contract or there is a specific name is there, this contract. Not mercantile contract, merchandised and especially ship contracts are there. And at that instance, they don't follow even Indian law, they don't follow the Japan law because they are not that much well developed. But England law is very much developed. At that instance, if any breach would be there, then the applicable law is England law. The party can choose, even though the party is not from the England. Because one party from India, another party from the Japan. At that instance, yes, these are called admiral contract. Admiral means through the ship. So such a contract, they can choose the England law because the England law is very much developed, especially in the admiral contract are concerned. So at that instance, the party can choose it, and it is not in contravention of any existing law of the either India or the Japan. Am I right?
Yes, sir.
Even they can choose a arbitral tribunal, either England or any other country also. If any dispute will be there, it will be resolved by that arbitrary tribunal. And the party agreed over there, neither the Japan Supreme Court or the Apex Court nor the India Court is having any jurisdiction to entertain such a case. You will study in the private international law this thing. Okay, the provision in any way interferes with the rights of the owner of the alienating this property and hence the considered strictly. So these contracts should be construed very strictly, like penal code, penal laws are constructed very, construed strictly. And the tax law are construed strictly. Are you following me?
Yes, sir.
There would not be any loose words. I don't know whether, because I wrote an article and that is published in the, what is the Bar Council of India will publish the journal name? Bar Council of India will publish the journal. What is the journal name? Sir, we don't know. Yes? Anyone? You don't know the journal?
No, sir.
See, here I have highlighted here. This is my article. Read.
Strict construction of penal statutes.
Hussain Mohammed Saheb, strict construction of penal statute. Next.
Indian Bar Review, Volume 32, 1 and 2, 2005, page number 133 to 142.
If you have in your bar room, Indian Bar Review, you check it. And you can find my article. And another article also, I published it, Indian Bar Review. Here, a review. Indian, when you make it review. Harmonious construction, I made it. Religion and law. Harmonious construction of another also I made it in the Indian Bar Review. Harmonious construction of, I think that is tax laws, I think. Oh, I could not make it out. So these are the two articles which I published over there and how the construction should be there. And these are all my articles which published in the various journals. Did you publish any article anywhere?
No, sir.
See, this is the already we studied here. Harmonious construction is there, another is. Let me. Yes. Oh, this I published in a different journal. Harmonious construction of a statute, Oriental Journal of Law and Social Science. And that is the published over there, harmonious construction. So, why I am showing this is tax law should be construed very strictly, and attachment laws will be construed very strictly. However, since it is for the benefit of the creditor, he can waive the benefit. If he wants, he can waive the benefit also, creditor. And a private transfer here means a voluntary transfer like a sale, lease, gift, mortgage. Then he can keep their own terms and conditions for the transfer if both the parties were agreed. But only the one condition will be very much clear, that it should not be against the public policy, number one. Number two, it should not be against with the existing laws of the country. And number three, it should not be in contravention with the constitution. So the court is included in a private transfer. Therefore, a private transfer in contravention with the section 64 is not wholly void. Suppose section 54, if you make a private contract, it's not wholly void against all other transactions, but is void only against the claims enforceable under the attachment, only to the action necessary to meet those claims. Only in certain extents it will be the void, otherwise it will not be void. When it will be void? When it will be contravention with existing laws. Number two, when it will be contravention with the public policy. Number three, when it will be the contravention with the constitution. So let us see the conclusion. In a civil suit, the decree holder has the benefit of the deciding mode of execution. So who is the decree holder here? Who is the decree holder here?
Plaintiff, sir.
Plaintiff. Why you are taking so much time to give a reply? So this attachment is only for the civil suits. So decree passed by the court against the judgment debtor. Here the against the judgment debtor means defendant. Is it clear?
Yes, sir.
So judgment creditor can choose from the various provisions mentioned in the code. He is a judgment creditor in the sense the plaintiff can choose from the various provisions mentioned in the code for the execution of a decree. He can't be forced or persuaded to choose a particular mode by court or any other person. So he cannot be forced to persuaded to choose a particular mode by the court or any other person. If the provisions allows it If the court allows it, then only you can choose such a mode. Attachment is the first step in the process of execution, either the movable property or the immovable property. So attachment is the first step in the process of execution, and the sale of the property will be carried out after the process of attachment. So you cannot harvest unless until you sow or irrigate. Am I right?
Yes, sir.
As you sow, so you reap. There is a proverb. As you sow, sow means, what is the sow spelling?
S4.
SOW. సో అంటే నాటడం అన్నట్టు, అంటే భూమిలో విత్తనం వేయడం అన్నట్టు, దాన్ని అంటారు. ఇస్ ఇట్ క్లియర్? సే yes.
Yes, sir.
As you sow, so you reap. Whatever you sow, suppose if you say the guava seeds, and you will get the జామకాయలు ఏమంటారండి ఇంగ్లీష్లో?
Guava, sir. Guava fruit.
Yes, that I told you. As you sow the guava seeds, and you will reap the
Guava fruit.
guava fruits. Sometimes the sale can be proceeded without an attachment of the property as well. So without the attachment, sometimes the proceed will be made. Of course, there the question comes, which are in a perishable nature goods. Am I right?
Yes, sir.
So we told you that is what are the tomatoes? If you keep the longer time, what will happen?
It will be rotten.
Rotten tomatoes. And there is another green tomatoes, we read it. Can you tell me what is the green tomatoes? Sappled tomatoes or something, we read it yesterday. SPALED, if I not be mistaken. Am I right? Green tomatoes are called tomatoes, sometimes called the husk tomatoes, like the green unripe tomatoes with a dry leafy husk that wraps around the outside. Small green tomatoes are called small green tomatoes. We yesterday we read that sign. A green spherical fruit and looks like a small tomato, in fact, means little tomato in Spanish, originated. What are the green tomatoes called in Spanish? No. Are green tomatoes called tomatillos? No, we don't know. Sappled, we read spalded or something. Spalded, spalted tomatoes, something we said. Not spoiled tomatoes, no. What did you tomatoes use to call? What are the tomato branches called? We don't know what is the tomato branches. Tomato suckers are produced and both determine an intermediate tomato plants. A sucker is a shoot that forms in the joint where a leaf meets the stem. Okay, we don't know this. Tomato plants, that is called suckers, tomato suckers. So anyway, but what we want to know is the rotten tomatoes. That is, we have to keep it in mind. So let us go to he cannot be forced to persuaded to choose a particular mode by the court or any other. Okay. Attachment is the first step in the process of execution. Second step is the attachment. No, attachment is the first step and sale is the next step. Am I right? And sometimes without attachment also the property can be sold if it is the subject is a perishable nature. This does not make the sale irregular in nature. So sometimes without attachment also the property will be sold when the subject matter is in a perishable nature and it is not against the norms. But naturally the correct procedure to be followed is the attachment followed by the sale of the property. The first comes attachment, next comes the sale of the property. Am I right?
Yes, sir.
Good. Attachment of the property being one of the modes of the execution of the decree recognize the right of the decree holder. Whose right is there for the attachment? Decree holder is having the right for the execution petition. He can move in the competent court, the same court, or the court which is competent to entertain such a execution order. Various amendments have been carried out in the court to protect the interests of both the judgment debtor and the judgment creditor. So there are various modes are there to protect the interest of the both the even a decree holder and a judgment debtor.
Judgment.
So these are the things would be there in the today class, and I did not make it the another question, but I will show you something which will be very much useful to you. And
Sir, please.
yes, please. Do you want to ask anything?
Sir, how to share the screen while presenting the paper? Can you please teach, sir, for 5 minutes?
See, suppose I am the host. I have the right to share my screen. Suppose, for instance, you are now you want to share the. Do you have anything on your laptop? Tell me.
Yes, sir.
Okay, now I am dragging. You can share it now. Advocate Gausia. Now you can share. I can see it. And there is a sharing is there. Arrow mark. On your laptop, there is a arrow mark is there. Down. You click it, double click it, the arrow mark, and you keep your file on the screen. I could see it. Either your photo or your file or anything, or your flower, whatever it may be. You click the arrow mark, share.
Sir, now I'm seeing in my phone, sir, cell phone. I just opened laptop, sir.
That's why I asked you. Did you on your laptop? Okay,
Yes,
doesn't
sir, I
matter.
opened.
You can open it, then I will share you. See, because
Yes, sir.
there is a ball is there, and that ball, what I do, I'll bring to the participants, and I will make him. Now you are the host. Means you can
Yes,
share your
no,
screen. I could see it, and you can. PPT is there. Yes, you can. In the international conference, they will do like that. Number one, number two, you will send the PPT first. They will share it, and they will. You will ask next slide. They will put the next slide. If you don't want in that way, I can give the share to you. You can share it. Did you open your laptop and kept it to run the Cisco WebEx?
Cisco is not there in my laptop, sir.
You can do only with the Cisco. How could you Zoom? You will make it out when your laptop is there. See, my platform is the Cisco. I can give the right for the Cisco to share with you. So you download the Cisco tomorrow in the
Okay,
laptop,
sir.
then I can show you that how to share it. When I draw out my ball, I'll make you host. Automatically, it will be shown you as a host. At that instance, you can, whatever the file that you want to share it, you can keep on the screen. The first screen you can make it out, the whole screen will be seen, and that would be seen to us. Then you can continue it. So that is the way of
Okay, sir.
sharing. So now, here the sharing is, I would like to make it now again, I'll share it. See, this thing I would like to share because I told you that I am going to present the paper in the international seminar. I don't know whether I put it for you or not. I don't think that I put it for you. This is the original file which I made it today and save. See, whatever that I kept it over there, that will be shown on the screen. This is my CV. I will close it. And this I would like to share it. So this is my research paper. I have shown my research paper yesterday. What is the name of the research paper? Read.
Emerging trends in legal tech, a new era for advocates in India by Professor Dr. Mohammed Saheb Hussain.
So I did not write the abstract. Actually, I should put the abstract not more than 300 words, including the 5 keywords. Of course, I sent this one. So this is my original. But how could you know it? How much percentage means you have to send it to the plagiarism. There is a plagiarism software is there. If you send your original file to it, then it will show how much percentage emerging trends.
Sir, please share that software to me, sir.
Which one you want to share?
That plagiarism software, sir.
It will not be there. What is the purchased one? You have to buy it.
Then how to buy, sir?
Yes, there is a procedure would be there, and you can buy it. So for me, the Yashpal Singh, and he bought for me. So sometimes he use it, sometimes I use it. So this is my original work, and you can drag it, and my percentage will be shown here. How much percentage?
15%, sir.
Yes. For the 15%, 20%, at the most 21, 23, 24. It depends upon the journal. Some journals they will accept only 10%, some journal they accept 15%, some journal they accept the 20%, and acceptable is only 20% below. And even 20 to 24 also will they consider it, but it's not the proper way. Because the 25% means you did your only 75% of your own and 25% you have taken from the other sources. So more better is the less than 20 is the good. So this is the 15% where we have made it out. All these things will be shown over here. Even you may be using the wrong proposition here, ETS. Proposition article error is there, SVS. Of course, sometimes it can be overlooked. But actually the percentage will be seen. This is the even article error also they will count. You may need to remove the article, they will say. ETS in the page number 5. So it also gives even a grammar. Sentence cap, review the rules of the capitalization. You can make it out. So this is the way. And this software is a purchased one, licensed one. It is not the free. So you have to buy online also, you can buy it. My software is a Turnitin, that is a software, which is generally the people use this software very well. And how could you know it? It is exactly how much it be there. I will show you even that also because the time is there. And this is the see, this is the actually we have to open it like this, login, and who purchased it, their login would be there. Oh, what is this? Parent login be saying. Sign with the Google. Here is the login is there. See, what I am showing you, if the green is there, it is acceptable. If the red is there, or yellow is there, or blue is there, the percentage is very much high. It will show. The software is Turnitin, Turnitin. If you type it in the Google search engine, and they will show you the mode of purchasing it. Of course, you need not to purchase. If you want to, suppose test it, you can write to them. They will say they will charge it depending upon the pages. Sometimes 80 rupees, 90 rupees, 120, 200. Depending upon the pages, they will charge it to you also. If you don't see, you have seen 33%. What is the color? What is the color?
Maybe yellow, sir.
Yellow color. Here 17%. What is the color?
Green.
Green. 63% orange. 22% light yellow. 71% dark yellow. 44% even a middle yellow. 83%, what is the color?
Red, sir.
Red color. So 21%, what is the color?
Green.
Green. 21% green color. Okay, why I am showing this thing is 23% green color, 16% green color, 34% yellow color, 11, 8 green color. If you 25 see yellow color. That means 24, they will 23 here. See, did you see 23 here? Did you see the 23 here? Say yes. Did you see the 23 is cursor? Green color. It's a green color. 24 also it is a
Green, sir.
green color. But 25 here I have shown you. 25 is yellow color. Here 25. Did you see this one? What is the color? Yellow color. That means they will allow up to 24%, but my policy is only 20%, or 20 or less than 20. So that way, here green, see this is 17. And today I tested, after my testing also my sir has tested too. 81% and 69%. See, this is this 15% is I will show you also view. The 15%. It is loading. See, this is did you see it? 15%. Is it my article? Say yes. Is it my article? Say yes.
Yes, sir.
So there is a 15% article it is. And here it will be shown. This is my article. 15% is my article. And 81 red color, no. We have to reduce it. 69, you have to reduce it. Then how to reduce it? The technique is you read the sentence and you make your own way the style of writing. Is it clear?
Yes, sir.
For instance, here I will show you. Of course, this I already made. Suppose, let me take the today's example. JCJ example I will show you. Today's, where is it gone? JCJ, attachment. For instance, a civil suit is instituted against an individual who causes some kind of harm or wrongful act to the plaintiff. A civil suit
विन्ध्य हिमाचल यमुना सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।